Welcome back to another episode of Divorce at Altitude. This is your co-host, Ryan Kalamaya. This week, we are going to be talking about the top 5 tips for anyone considering a premarital agreement. And I'm going to be joined by our senior associate, Elizabeth Hardman. She does do drafting and negotiating premarital agreements for our firm. And for listeners, they likely know that we've had various other episodes. Most recently, Amy and I did an episode on Kevin Costner's premarital agreement and the challenges. And so we've really focused on the litigation and the risk of premarital agreements. It's something that my practice has a particular emphasis on. And so you see the downsides of premarital agreements. This episode is going to be a little bit different. We're going to talk about the benefits of a premarital agreement, and for those considering whether they're attorneys or more likely parties that are engaged or thinking about getting engaged, that are weighing whether or not to have a premarital agreement or a prenup. And so we're going to talk about that. So Elizabeth, before I go on, welcome to the show.
Thanks for
And we'll have a separate episode on who Elizabeth is. So for those that are interested, check out our podcast feed, because there will be an episode in particular on Elizabeth's background. But Elizabeth, to set the stage for listeners that may not understand what a prenup is, or what are we talking about here in Colorado?
Of course. I think most people refer to them as prenuptial agreements. That's the common terminology you hear. In Colorado, we refer to them as the premarital agreement. And in Colorado, a premarital agreement is an agreement between individuals who intend to marry that affirms, modifies, or waives a marital right or obligation during the marriage or upon separation or divorce. And so it really helps set the stage for the marriage and create kind of those financial expectations between spouses.
And I think also it's also helpful for listeners, not only in their marriage. I think it is helpful for people to go into their marriage with a written document about how financially they're going to handle various things or who gets what. There's also a benefit. We don't do estate planning, but if a husband predeceases a wife, then if he has kids from another marriage. And so there are some benefits to having some certainty. And so maybe could you comment a little bit on that in addition to what you already covered, Elizabeth?
Certainly. So I think I've read a lot of statistics about the impact of finances on the marriage. And I've read a bunch of articles recently that really stress that arguments surrounding finances are the second leading cause of divorce. So I think it can really help parties to sit down, especially when you have really disparate financial circumstances, for one spouse to say, okay, how do I make sure I protect assets if this doesn't go well? And on the flip side, for a spouse who might not have the same financial background, how am I going to be assured that if our marriage is unsuccessful, that I'm going to be okay, that I have some resources to get back on my feet? And I think that does create a lot of stability in the marriage, especially when you're talking about getting kids involved. The pre-marital agreements, though, however, you cannot include provisions that limit, for example, child support or other child-related provisions, because that's always going to be modifiable by the court and always going to be looking at what's in the best interest of the children. I do think it's really important as well to hire an attorney to deal with the estate planning piece who has experience in that realm. Our firm doesn't do that right now. So we do have referrals in that regard, but you do want to make sure that you know what will happen if you predecease your spouse and where your resources are going.
Right. And I mean, that's just another example of knowing your kind of lanes and your specialty. I mean, I think a lot of times I had someone consult with me just recently. They'd done the premarital agreement on their own, and they had included, for example, child support or parenting time. And unfortunately, I had to advise them that these are not enforceable. So we'll get into the tips, and one of them will be just as a kind of a preview of obtaining legal counsel. But I think that there are some real benefits both in the marriage where parties have to have that discussion about finances. I was just recently talking to a friend about that some people get married without having really discussion about whether or not they want to have children. But other people, they do go into a wedding or a marriage and they haven't really figured out how they're going to work their finances. And Elizabeth, as you and I have seen through divorce, the process, there are just so many different ways that people handle money. Some will throw everything into a joint account. Some will just maintain completely separate financial lives. I think having that discussion ahead of time through the process of a premarital agreement, because you have to have that discussion in advance, I think it is helpful. And I certainly know of friends or clients who feel much more certain in their marriage because of a premarital agreement. So there is that benefit. We really talk about, well, this is what happens in a divorce, but there are circumstances definitely where people have stayed married or have gotten married because they knew of these certainties. So there's some real benefits to having a premarital agreement. Then you also have the benefit of if the divorce happens, the marriage fails, it makes it simpler in circumstances where there's a valid agreement, both parties acknowledge that, they then have an understanding as to what is going to happen. So any thoughts on that based on your experience dealing with premarital agreements or marital agreements in a divorce, Elizabeth?
I completely agree with what you're saying. I think with many people that I've talked to, when they come to me, they haven't even really thought about how they're going to be splitting expenses, who's going to be paying for what their bank accounts are going to look like. So that's really common. It's just not at the forefront of your mind when you're getting ready to get married and you're starting your life with someone. So even just having the premarital agreement being the driving force behind you, taking the time to sit down with your soon to be spouse and figuring out, okay, what makes sense for us? How are we both going to feel comfortable moving forward? I agree with that entirely.
Well, we'll get into the tips. I think the other thing that is worth mentioning is that generally speaking, in order for there to be a valid agreement, premarital agreement, it needs to be in writing. It needs to be voluntary, and there has to be adequate financial disclosures. And that third point is one of the most kind of overlooked aspects, that because it's not like, Elizabeth, if you have a plumber come to your house or I agree to do something where there's a written agreement, these are special contracts. They're between people that have presumably an intimate relationship. And the law recognizes that there is a height standard and there is a kind of a couple plus factors that are required in order for these agreements to be valid. So with that in mind, let's jump into it. Tip number one for drafting and negotiating a premarital agreement. What's tip number one, Elizabeth?
Tip number one is going to be start early. I cannot tell you how many potential clients we have had contact the firm and they're getting married in a month or less, in a few weeks. And they hope to cobble together a premarital agreement really quickly. And I think just really underestimating the work that does go into a premarital agreement, and more specifically with what you just referenced, the financial disclosure aspect. And that can be quite time consuming. And you want to make sure that each spouse has the time to properly review the other spouses or soon to be spouses' disclosures and really analyze those, ask for additional documentation if needed, more information, because the last thing that you want to happen down the road is that the agreement is later invalidated because it was rushed.
Yeah, from a litigation perspective, one of the questions I ask potential clients when they come to me and they say, I want to get a divorce, and they mention a premarital agreement, we talk about what were the circumstances of the negotiation? How long did it take? And the fact that it happened the day of the wedding or the day before, that definitely gives rise to some opening. It's not mean that it's invalid. It just gives rise to the argument. But I think to your point, Elizabeth, mistakes happen when things are rushed. And the discussion that occurred between us, our firm, and a client negotiating a premarital agreement it takes some time in terms of, did you think about this? What if you have kids? What if you buy a house? Have you guys talked about that? And a lot of people, they haven't had those conversations or they haven't thought about it. We can't have those conversations and turn around a draft and give them their various options of what can go into an agreement in a matter of a day or even a week. And so you got to start early in order for there to be a valid agreement. And if you don't, then most likely our firm is not going to take it on. And the reason is that there's just a risk of there being an argument that's going to be set aside.
Right. And I think in addition to the risk that something might fall through the cracks, be left out. So you might have some accidental financial disclosure issue, or the fact that the court might just generally look at a premarital agreement that's entered into right before the marriage as a little bit suspect from the start. I think you have to be really careful in situations where there might be an argument by a spouse later down the road that they were coerced or under duress at the time that they signed the premarital agreement. That can get into really fact specific information, but certainly if I'm talking with a client where there might be, if there was any history of domestic violence at all or anything like that's going to be a big red flag, I think, in the court's eyes.
Great point, Elizabeth. Tip number 2.
Yes. So tip number 2 is to provide open and complete financial disclosures. And for that piece, again, we're talking about two people who are about to enter into their marriage together. And to really create an agreement that is fair, there needs to be a full understanding between the two of you as far as, well, what are all of the assets and debts that each of you have. It's really important, and in my view, probably one of the easiest ways for a premarital agreement to be invalidated.
Amy and I just had a discussion on an episode on Kevin Costner's divorce, and there was a premarital agreement, and it's been all over the news. And one of the arguments was that the disclosures reportedly were off. And so, like you said, Elizabeth, you have to go through that process and really provide complete disclosures. The reality is that it's helpful for a number of reasons, financial disclosures. One is that under the law, that any property that's owned at the time of the marriage is separate property. And so when you go through that process and you document that separate property, then that is helpful in and of itself. But the second thing is that most premarital agreements, or at least one option that I would say is the most common, is an agreement that any appreciation or increase on that separate property remains separate, which is a change from Colorado law. Colorado is pretty unique. We've talked about it on the podcast in multiple episodes about how progressive or how unique Colorado is. But I do think that is probably one of the most common terms. Wouldn't you agree, Elizabeth, in a premarital agreement about that appreciation on separate property?
I do agree with that. Yes.
And you have to know what you're giving up. And you also have to know when you're entering into this agreement, when, for example, if you say no maintenance or no alimony, and if in our hypothetical divorce client, if Eric and Melanie Wolf are negotiating a premarital agreement, if Eric's making $1 million a year and Melanie says, I'm waiving maintenance, she has to know that he's making $1 million a year to begin with. And she also has to know that he has a business. And a lot of people are like, well, duh, like they're presumably they're engaged. They know each other's financial circumstances, but a lot of times the other party, Melanie, actually doesn't know. And so we have to walk Melanie through that process of making sure she understands what Eric's financial circumstances are.
Yes, that is absolutely true. And along those same lines, I think what you also see is one individual themselves might not even realize their own assets, especially in the situation where you have people with family trust. And so it's really important to be asking those questions, asking family members, am I a beneficiary of a trust? What does that trust look like? And making sure you get ahead of that so it doesn't become an issue later down the line.
And I think that kind of a sub tip on this particular point is to make sure that financial affidavit or the financial disclosures, they're provided in time. So that kind of relates to our first point, our first tip, but also that there is an acknowledgement or there's a record that those financial disclosures, whether it's included in the agreement or there's an acknowledgement, because I've seen cases where the financial disclosure, there was an initial or a date and it was after the date of the wedding. And that gave rise to extensive litigation, or there was a question of whether or not it was or was not attached because the agreement just referenced financial disclosures, but it was unclear as to whether or not what exactly they were. So having the whole document, the whole agreement encompass or include those financial disclosures along with kind of initials or assurance that it was provided at the time of the signing, I think is a related tip.
I agree. That's really important. And we will create essentially an exhibit that lays everything out, make sure both parties initial that to acknowledge it. But I do think that's important. And I think one other thing that I've seen as well in a case is make sure to update the disclosures. At the beginning of negotiations, if you exchange documents at that point in time, but there's a material change that happens in the value of any of those assets or debts, it's really important that you update them before signing because that also can be grounds under the specific circumstances to invalidate it.
Well, that brings us to tip number 3, which is
That is to seek legal counsel for both parties. This is also a really important one in my view. It can really cut against any challenges to the premarital agreement regarding coercion, duress, and just a lack of understanding of the agreement itself. One thing that I think is interesting in Colorado too is that if one party to the agreement doesn't have the financial means to obtain their own counsel, but the other party does, the more financially advantageous party really should be offering to pay for an attorney for the other party.
I agree. I think something unrelated to that is that it makes sense to pick the attorney for, if you're going to be paying for the attorney, if Eric is going to be paying for Melanie's attorney, oftentimes Eric will say, pick, or I'm going to pick for you, or we'll talk to his attorney and say, who do you work with? Who does these? It's ideal if Melanie just finds her own attorney, because then there's no allegations that Melanie's attorney is just like a straw man, or certainly have seen that. But I think Eric needs to be prepared to pay for Melanie's attorney if he really wants a valid agreement, because I heard a presenter on CLE for premarital agreements say that if there is anything that makes an agreement valid, it's having two attorneys involved, because it's really hard to argue that you didn't understand it or that it was unfair or any of those circumstances, because the judge or any decider is going to say, well, it sounds like your beef is with your attorney. And that is more of a malpractice claim than the agreement is invalid. But I think that is a really key point. And it's something our firm does not get involved with any premarital agreements unless there's going to be attorneys on both sides. Elizabeth, that brings us to our 4th tip on drafting and executing premarital agreements, which is?
Tip number 4 is make it fair. I think you see a lot of people want to go into this. And like you said, make sure we keep all the appreciation on my separate assets. And I want to keep all of my pre-existing assets in the future. If you have a huge disparity in financial circumstances between the parties and you don't give some sort of concessions on finances and make sure that the other party is going to be able to survive, and not just able to survive, but able to live generally within a lifestyle that you anticipate to be created during the marriage, you could be in some hot water looking at enforceability issues.
Yeah, I totally agree with that. And I think it really depends on the facts and circumstances. So Kim and Kanye, they had a premarital agreement. I haven't watched, I think it's on HBO or Max, the Kim and Kanye divorce documentary, but I mean, that they both were very well known. Tom Brady and Giselle, like they both were highly successful. If they're giving up or saying, hey, what's yours is yours and what's mine is mine, that is a different circumstance than if Eric and Melanie Wolf go into a wedding and Eric makes $1 million and he just met Melanie and she is a school teacher and they haven't had yet kids. She gives up her career. And those, it really depends on those circumstances, which I think is to the point of having legal advice and starting early because we can have those discussions of, hey, if the mom is going to give up her career, do you want to provide for that? And it doesn't have to be in child support. As we mentioned, child support, you're not going to have any sort of provision, but it can be that you're going to provide a house or some lump sum payment. One common thing that we will see is for 1 to 3 years of marriage, there might not be a particular amount of payment, but 3 to 5 years, there's a payment of $100,000 or fill in the blank amount and so on and so forth, because it acknowledges that disparity in potential earnings and it can be magnified over time. If you're talking about a 20-year marriage, that can really matter. And likewise on maintenance, there could be, hey, given the circumstances right now, I'm going to pay you $1,000 a month and that's indexed with inflation. That's going to be more likely to be enforceable, even if it's lower than what would happen instead of just saying zero, but having it fair. I think in it, the other aspect that I think it relates to is going into a wedding. If you have just a completely one-sided agreement, how do you think that lands in the marriage with the understanding that, hey, I get all of my money? It's just not a great feeling for Melanie Wolf if she's the one that doesn't have the money and Eric says you get nothing.
Completely agree with that. I think that this also is important for people to consider that circumstances might change during the marriage. So when you get married, you might not know if you want to have kids yet. You might not know if one spouse is going to ultimately be a homemaker. And so I think it's really important too for spouses to almost revisit the premarital agreement, I don't know, on an annual basis, and it's not longer, to just make sure that the premarital agreement still is fair, given any changed financial circumstances. And if it's not, you can always modify or amend the marital agreement to make it fair, to keep that control so it's not just going to be invalidated.
And to the point of fairness, we've certainly seen agreements where the parties anticipate buying a house together. There might be some difference in the down payment, and you could document that one party, Eric, gets his money back from the down payment, and Melanie gets hers, and then they equally divide it, or they divide it on pro rata share. But we have seen where it's fair to equally divide it at the time, and they're going to buy a house, but if it's just completely just really one-sided, then it's going to result likely in a challenge. And that is, you're going into an agreement, presumably to reduce conflict, to reduce certainty. And when you make it so completely one-sided, you give rise to the very thing that you're trying to do away with.
Exactly.
So tip number 5, Elizabeth, what's our final tip when negotiating a premarital agreement?
So our final tip is be prepared to walk away either from the wedding or from the premarital agreement. If it's not fair and you can't get fair provisions, you need to be ready that those are your options. You can move forward with the wedding without one, or that's it. So yeah, sorry.
No, the judges, what they say whenever someone says, well, I was forced into it, I didn't want to sign it, I was crying, they forced me into it. The judge will say, the response to that is, well, no one forced you to walk down the aisle. And I've heard it where Melanie will say, well, my friends were coming in, my family, I planned this whole wedding. I had so much on the line and I was going to be embarrassed. And all of those things are true and very understandable from like a human perspective of how embarrassing that would be. But no one forced, Melanie to walk down the aisle. Now, and she needs to be prepared to say either I am not going to walk down the aisle because I deserve more in this agreement, or the counter is that if she's unwilling to sign it, Eric needs to be prepared to either decide, this is not something I don't want to get married unless there's a premarital agreement. And that might result in them calling off the wedding or breaking up. Or he might say, you know what? I want to marry Melanie so much that as much as I'd like to have a premarital agreement, I'm not tied to it. So both parties need to be able or willing to walk away.
Right.
Anything else that listeners might benefit from, Elizabeth, with premarital agreements? I think we've covered a variety of topics, and there are more than 5 things that go into having a valid premarital agreement. One thing that we like to do is to videotape them, because it then shows that people that they didn't have a gun to their head. It ameliorates the issue on voluntariness, because if there's a later challenge and it shows them kind of laughing about how this will never result in a divorce at the time of the signing on a video, and that everyone was there, or that there was one person that, but sometimes it's not practical, e-signature and having those documents on file. But I mean, there's so many different ways that we can cut this up. But Elizabeth, any other kind of final points that come to mind?
Yes. So, along the same lines of what you're referencing as far as videotaping the actual signing, which I have heard some mixed reviews at CLEs from different judges on that point. I my personal opinion is that it cannot hurt you to do that. It's more evidence of lack of coercion. But for document keeping purposes, I recommend that any person who is entering into a premarital agreement keep a USB drive that includes the final copy of the premarital agreement, any drafts that you might have had, and all of the financial disclosures that you provided, especially if you provided additional documentation aside from just an exhibit with a list. If you provided tax returns, have that all in that folder. If you can keep it in a safety deposit box or someplace that's secure where you will never lose it. That's really important. Believe it or not, we have had situations where a spouse has tried to destroy the only copy of the premarital agreement, and that leaves the spouse who wants to enforce it in a really bad position. So I definitely recommend keeping a good record.
Or they can't find it. And,
Right.
I think duplication, emailing it to yourself, saving to your Google Drive or Dropbox, and then having a USB file, and just knowing that you've got that certainty. I 100% agreed. So, well, hopefully this has been helpful info for anyone considering a premarital agreement. And we are entering wedding season. So congratulations to those that are tying the knot, and best of luck going forward. And if it includes premarital agreement, hopefully this information helps.